Good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our state all-purpose calendar for today, March 6, 2025. These are cases in which individuals who were recently arrested and accused of some misdemeanor offenses. Excuse me. Today, we are going to get a status of their cases. If you are an individual charged with one or more misdemeanor offenses, please remember you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Hopefully, most of you have had an opportunity to speak with a defense counsel, so we will get a better idea of what's going on with your cases. We will be addressing possibly plea hearings, or we will arraign the cases for trial. Also address bond modifications, a competency calendar, and I am not sure if I've got any DV bench warrants this morning. Do we? Yes? No?
No, ma'am.
Okay. All right, let's proceed with courtroom 2. Who do we have?
Position number 2, Mr. Elliott.
Oh, it's my add-on calendar. Okay. All right, this is Orville Elliott, accused of cruelty to animals, terroristic threats and acts, and willful obstruction of a law enforcement officer. Mr. Elliott, your case number is 25 CR 880A. You have been advised of your right to remain silent, and your attorney will be Mr. Tom White. Mr. White, is this going to be a plea?
It is, Your Honor.
All right. Mr. Elliott, please raise your right hand. You solemnly swear and affirm the testimony you provide for the plea will be the truth to the best of your knowledge. You need to say yes or no, Mr. Elliott?
Yes.
All right, that's good. Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation on count 1 is 12 months served 30 days, credit for time served 15 days. That's from February 19th, 2025 until today. Balance probated. The defendant is not permitted to own any animals during the period of probation. We are also requesting a $500 fine, and the defendant attend animalcourts.com online course. Count 2, the terroristic threats, is 12 months served 30 days, credit for time served 15 days, balance probated. No further contact with Tasha Peters and Latoya Matthews. Stay away from city views at Rosa Burney Park Apartments unless the defendant still resides there, and 12 weeks of anger management. Count 3 is 12 months concurrent to count 1. That's the willful obstruction with a $300 fine. We did have an opportunity to speak with the victim, who stated she works in the leasing office. She stated that the defendant has threatened other residents previously, and she's concerned for her safety and does not believe the defendant should be allowed to return back to that property. She also believes the property manager is planning on evicting this defendant. And she is here on Zoom, so we would like to sound at this time for Tasha Peters and Latoya Matthews. That's all for the state. And we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
All right, Ms. Champion, do we have anyone in the waiting room, or Ms. Hawkins?
No, ma'am.
All right, so I don't see Ms. Peters or Ms. Hawkins. I mean, Ms. Tasha, what was it? Peters and who?
Tasha Peters, and the second victim is Latoya Matthews.
All right, no one's unmuted and started that video on those names. Mr. White, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
All right. Mr. Elliott, you have heard the recommendation from the prosecutor. Now I'm going to ask you some questions. You would have to respond either yes or no to these questions. I'll have to determine whether your plea of guilty to these charges is being entered freely, willingly, and knowingly. Do you understand, sir?
Correct.
I can't understand your response. What did you say?
I said correct.
Have you consumed any medicine or alcohol recently?
No. Oh,
Have you-
yeah. I took they gave me like some type of medication one morning or something. So
And after consuming the medication, are you still able to follow the proceedings today?
yes.
Do you understand what's going on in your case?
Kind of, sort of, yeah.
Kind of, sorta is not good enough. What do you not?
I don't understand the fact that I live there and yeah, what Miss Falk said, I live at Rosa Burnham.
Your Honor,
Go ahead.
with the fact that he is currently a legal resident at the apartments, we would ask for the stay away to be lifted. If if they need to evict him, they can go through the legal channels to do that. But as far as at this point, he's still a resident there. He's on the lease. We'd ask that be stricken from the plea.
Right, and that's why the plea offer specifically states stay away from there unless he resides there. That's why I made the offer structured the way that I did, because I wasn't sure if he did or not. If he does, then the stay away obviously would not apply.
The condition is, Mr. Elliott, that you can return to the apartment complex and you can stay there unless, of course, the landlord has barred you from the property, and that's a whole different set of laws. Or if the landlord has started a dispossessory action or an eviction case, and then it's up to you to decide whether you want to continue residing there and fight the case, or whether you want to voluntarily vacate the premises.
I have a question.
What is,
I'm ahead on my rent, so if they do evict me, I get my money back?
That this court can't determine that.
Oh, okay.
all right, again, I'm going to ask you, now, do you have an understanding of what's going on in your case?
Sort of, yeah.
Mr. White, I'm not going to take this plea and take this.
Yes.
These
I'm sorry.
responses.
I said mostly, yeah.
Mr. Elliott, sit up straight, and I want you to pay attention. I'm going to ask you this third and final time. Do you understand what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
And if you decide to plead guilty to these charges, are you doing so freely, willingly, and knowingly?
Yes.
If you decide to plead guilty to these charges, as I'm sure Mr. White has explained it to you, you will have to give up your constitutional right to a trial. You will not get the opportunity to have a trial in front of a judge or a jury, to go back to court to confront your accuser, challenge the evidence brought against you, be able to present your legal arguments, defenses, and arguments. And also, the prosecutor will not have to carry her burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? I can't hear you.
Yes.
How do you plead to cruelty to animals?
Guilty.
How do you plead to terroristic threats and acts?
Guilty.
How do you plead to willful obstruction of a law enforcement officer?
Guilty.
I'm sorry?
Guilty.
Your sentence for count 1 is going to be 12 months to serve 30 days, credit for time served 15 days. So if you have no other holds at the jail, you should be released within 24 hours. You must report to the Fulton County Probation Office on Monday, and that would be, is it March 10th? Yes, it's Monday, March 10th, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. You will be on probation for the rest of the year. And while you're on probation, you're not allowed to own any animals, not even a bug. And this will be for the entire remainder of the 12 months that you're on probation. You will also pay a $500 fine for count 1. Within 60 days of being released from jail, you will enroll in a program called the animalcourts.com course. Again, it's animalcourts.com. It's a program that is offered, and you'll be required to enroll and complete the program and present your certificate of completion to your probation officer. For count 2, your sentence is 12 months to serve 30 days, credit for time served 15 days, balance probated. You are to have no contact with Tasha Peters and Latoya Matthews. If these are individuals who work at the leasing office, then you'll be required to stay away from the leasing office. Your only mode of communication with the leasing office will be via computer or by phone. Of course, you can enter the leasing office if Ms. Tasha Peters and Ms. Latoya Matthews are not there. But if they are there, you cannot enter the office and you're to stay 50 yards away from them. You can return to the city views at Rosa Burney Park Apartments unless you have already been evicted from the place, unless you are legally barred from the place, or you voluntarily decide not to live there. And for count 3, willful obstruction of a law enforcement officer, it'll be 12 months probation concurrent to count 1, and it will be an additional $300 fine. Your total fine is $800 plus court costs and probation fees. You will make a minimum payment of $100 per month to your probation officer until all charges, fees, and fines have been paid. Any questions, Mr. White?
No, Your Honor.
All right. Thank you, Mr. Elliott. That concludes your sentence.
Thank you, Your Honor.
Next case, please.
Position number 7, Mr. Harris.
There we go. Oh, thank you. All right, number 7, Mr. Harris. Xavier Harris is accused of giving false information to an officer and loitering and prowling. His accusation number is 25 CR 001037D. Mr. Harris, you've been advised of your right to remain silent. Your attorney is Mr. White, and position 7 is going to be a plea. Mr. Harris, may I place you under oath, please? All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? All right, you have to say yes or no.
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. As to counts 1, giving false information to law enforcement officer, and to count 2, loitering and prowling, the recommendation is time served. 324 days, credit for time served 162 days. That is from September 24th, 2024. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We stipulate, Your Honor, nothing further.
Mr. Harris, have you consumed any medicine or medication? I mean, medicine or alcohol? No?
Yes, Tommy.
So you see, I'm up on the screen, and
Your
even though
Honor.
it's monitor, I'll need to be able to hear you, Mr. Harris. So have you consumed any medicine or alcohol?
You need to say yes or no. You need to say yes or no. Don't shake your head. Just say yes or no. Have you consumed any drugs or alcohol? That's what the drugs are.
No.
Thank you. And do you understand what's going on in your case?
Yes. Yes.
Are you happy with your attorney?
Yes.
And Mr. Harris, if you decide to plead guilty to these charges, you will not have a trial. You will not go back to a courtroom. You will not face your accuser. You will not be able to challenge the evidence. And the prosecutor will not have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
And how do you plead guilty or not guilty to giving false information and loitering and prowling?
Guilty.
Repeat that.
Guilty.
All right. Your sentence is time served, which is 324 days, credit for time served 162 days for both counts. So your obligation for this case is over, and you should be released within 24 hours unless you have anything else holding you. Thank you.
Thank you, Your Honor.
Good morning, Judge Law. This is going to be position number 3, Ms. Ferguson.
All right, thank you, Francois. Good morning. We have Tyrona Ferguson, case number 25 CR 881, accused of disorderly conduct from February 2025. Ferguson, you have a right to remain silent and to say in open court. Your statements can and will be used against you. You have a right to an attorney, and representing you at this moment is Mr. Shatai. And this is going to be a plea. Ms. Ferguson, if you please raise your right hand. Ms. Ferguson, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Do you so swear? All right. Ms. Ferguson, can you hear me? Ms. Ferguson, can you hear me? All right. Mr. Shatai, your client appears to be non-responsive in terms of verbal responses. Have you had a chance to speak with her?
Yes, I've had a chance to speak with her.
All right. Ferguson, my name is Judge Lal. Can you hear me? Francois, is the microphone close to her, or is she?
Yeah, she just needs to talk loud, and she's not talking loud.
All right, Ms. Ferguson, if I cannot hear you, then I will see you next week, and you'll spend an extra week in jail. So it's entirely up to you whether you want to respond or whether you want to wait another week.
Ms. Ferguson, speak as loud as you
A lot louder. My name is Judge Lal. Can you hear me, Ms. Ferguson? Yes or no?
You don't need the commentary. He has to talk, she has to hear. I hope when y'all get up here, y'all can talk just as loud.
I heard a yes. Thank you. Okay. Ms. Ferguson, again, raise your right hand and listen to my question. And do you swear that the information you provide for this plea will be the truth to the best of your knowledge?
Ms. Ferguson, speak as loud as you can.
I can't hear her. I can't conduct a plea if I can't.
For me.
All right. Courtroom 2, I'll take another case. Oh, I'm sorry, ACDC, I guess we'll do another case.
Position number 9, Mr. Eric Johnson.
Okay. Francois, I'll be with you shortly. Position number 9. Edward Johnson is accused of theft by shoplifting from January 23rd, 2025, case number 25CR918Y. Mr. Johnson, my name is Judge Long. You've been advised of your right to remain silent, and your attorney is Mr. White. And this is going to plea, Mr. White?
Yes, Your Honor.
All right. Mr. Harris, Ms. Johnson, excuse me, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. Ms. Falk?
Yes, Your Honor.
I'm sorry.
No, actually, I think this one is mine.
Okay.
The defendant was charged with, this is Edward Johnson, correct?
Yes.
Correct.
Defendant is charged with theft by shoplifting. The recommendation is 12 months served 60 days, credit for time served 13 days from February 22nd, 2025 until today. Anti-theft course, 40 hours of community service, a $500 fine, and stay away from all Home Depot locations. There's a notation on here that I made that this would be a violation of his previous case, 24 CR 008246Y, which also happened at the Home Depot location. We do ask the defense stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
So stipulated, Your Honor.
So
I'm sorry.
17 more days at the jail?
That's correct.
Okay.
And we would just ask that the probation go non-reporting upon completion.
I'm sorry, no, this is a violation of another matter on probation, so he'll have to remain on probation for 12 months. Mr. Johnson, the court is going to require you to remain on probation for the remainder of the 12 months, which is going to be 10 more months on probation for this case, in addition to probation for the other case.
Okay.
Do you still want to continue?
Yes, yes.
All right. Mr. Johnson, have you consumed any alcohol or medicine?
No. Not like in here, no. Out there, yeah. Just one time.
Nothing that you,
He's asking about right now.
Oh, right now? No.
And have you understood what's going on in your case?
Yes.
All right. Are you satisfied with your attorney?
Yeah.
And when you spoke to your attorney, have you decided to enter a guilty plea to this charge freely, willingly, and knowingly?
Yes.
You understand that you were previously convicted of shoplifting at Home Depot?
Yes, ma'am.
Mr. Johnson, do
Yeah.
you understand that you were previously convicted of shoplifting at a Home Depot?
Yes,
And
ma'am.
this will be a new conviction for shoplifting at Home Depot.
Yes.
So you understand that one of the conditions is that you cannot enter a single Home Depot store.
Okay.
You have to stay away from all of them.
All right.
Is that something you're willing to accept?
Yes.
Are you also willing to accept that you would have to give up your right to a trial? You will not go back to a courtroom. You will not face your accuser, be able to challenge the evidence brought against you, and have your attorney present your arguments and legal defenses. And the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How are you pleading to theft by shoplifting from January 23rd, 2025?
Guilty.
Your sentence is going to be 12 months to serve 60 days, credit for time served 13 days. You have an additional 17 more days to serve at the Fulton County Jail, after which you'll be released, and within 48 hours, you must report to the probation office at 132 Mitchell Street in downtown Atlanta.
Okay.
You will have to report on a Monday, Tuesday, or a Thursday before 3 p.m. While you're on probation, within 60 days, you are to enroll and complete an anti-theft class, do 40 hours of voluntary community service with a minimum requirement of 5 hours per month. You must pay a $500 fine with a minimum requirement of $50 per month plus your probation fees. And you're required to stay away from all Home Depot stores. There's service, there are fines to be paid, probation fees, and you can't go shopping at Home Depot.
Okay.
Understood?
Yes, ma'am.
All right. Don't forget to report to probation. That concludes your sentence.
Thank you, ma'am.
thank you, Your Honor.
Yes.
Francois, who do we have, please?
This is position number 8, Jenkins.
All right. 888. All right. This is Ellis Rufus Jenkins, accused of giving false information to an officer and willful obstruction of an officer from December 3rd, 2024. Number 2CR 790. Mr. Jenkins, you have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is going to be Mr. Shatai. This is going to be a plea hearing. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Shatai? Oh, excuse me, Ms. Fall?
Yes, Your Honor. The state's recommendation on this case is time served on counts 1 and 2, giving false information and willful obstruction. 188 days, credit for time served 94 days, which is from December 3rd, 2024 until today. We ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the court. all for the state, excuse me.
I wish it was all over the court sometimes, but not right now. Okay, Mr. Chate, do you still stipulate?
Stipulate, Your Honor, and this is a negotiated plea.
All right, thank you, sir. Mr. Jenkins, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to enter this plea, you would have to give up your right to a trial. You will not go back to a courtroom to face your accuser, challenge the evidence brought against you, be able to present legal arguments and defenses, and the prosecutor will not have to prove the charge against you or the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of giving false information and willful obstruction of law enforcement officers?
Guilty.
Your sentence is for both counts is going to be to serve 188 days, credit for time served 94 days. Your obligation for this case is over, and if you have no other hold, you will be released within 24 hours. Thank you.
Yes, ma'am.
Yeah, Judge, quick question. So for position number 3, Ms. Ferguson, what are we doing with her?
We'll try again, and then we'll see how far she gets. She seems to be in a daydream, so I just want to make sure she's awake. All right, Ms. Ferguson, let's give this another shot. Now remember, you've heard the other previous cases. They speak nice and loud, and I don't have a problem hearing them. But if I have a problem hearing you, then I can't proceed, and you'll have to wait until you get into an actual courtroom where we'll put a microphone in front of you. Are you prepared to go forward today? Can't hear a word.
Yes.
Very good. We will resume with 25 CR 000881Y. And this is a resumption of the plea hearing in which Ms. Ferguson is accused of disorderly conduct. Ms. Falk has already allocated the terms. Oh, excuse me. No, she has not. Ms. Ferguson, do you solemnly raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Ms. Falk? Oh, sorry, unmute, please, Ms. Falk.
Thank you, Your Honor. For the charge of disorderly conduct, the recommendation is 12 months served, 30 days, credit for time served 15 days from February 20th, 2025 to today. 12 weeks of anger management. Stay away from the Taco Bell located at 2951 Legion Way in East Point. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. This is a balanced probated sentence. That's all for the state.
Mr. Chate, do you so stipulate, and does your client accept the terms?
Yes, Your Honor. I stipulate the client accepts the terms, and I'd ask the court to consider to have my client go on non-reporting status after completion of both courses.
Well,
No objection.
all right. Well, I was going to say, let's see how far we get. But Ms. Ferguson, have you consumed any medicine or alcohol recently? Can't hear you.
No.
Are you satisfied with your attorney?
Yes.
And have you understood what's going on in your case?
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to a trial, to confront your accuser, challenge evidence that'll be brought against you in a courtroom, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of disorderly conduct at the Taco Bell?
Guilty.
Your sentence is 12 months to serve 30 days. Credit for time served 15 days. Let's see. Oh, yes. You will report to probation on Monday, March 10th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 12 anger management classes, and you are to enroll in those classes within 60 days of being released. and complete all 12 anger management classes. At all times, you must stay away from the Taco Bell store at 2951 Legion Way in East Point, Georgia. Once you have completed your 12 anger management classes, you have paid your probation fees and all costs, then your probation may be non-reporting. Thank you. Is Mr. Elliott still in the courtroom? I think I forgot to include the 12 anger management classes for count 2. Orville Elliott?
Your Honor, we went over he was clear about that.
Okay, all right. In that case, Ms. Champion, I forgot to state that, but he's required to complete 12 anger management classes on count 2.
Yes, ma'am.
Thank you. Who do we have in courtroom 2?
This is position number 6, Mr. Gray.
Your Honor, I got a chance to speak to Mr. Gray. It's going to be a negotiated plea.
Thank you, Mr. Haddad. This is State versus Donald, Donnell, Gray, Gray, 25 CR 863J. Mr. Gray is accused of criminal trespass, willful obstruction of a law enforcement officer from February 18th, 2025. Mr. Gray, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Paul?
Yes, Your Honor. The state's recommendation as to the criminal trespass is 12 months served, 34 days. Credit for time served, 17 days. That's from February 18th, 2025. Balance suspended. Stay away from the Walmart located at 4735 State Route 138 in Union City. On the willful obstruction of law enforcement officers, count 2, it is time served, 34 days. Credit for time served, 17 days. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Judge, we stipulate for purposes of the plea, and we just ask the court to follow the negotiated plea, Judge.
Mr. Gray, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to enter this plea, you would have to give up your right to a trial in front of a judge or a jury. There won't be a chance to confront your accuser, challenge evidence brought against you, present your defenses and arguments, and the prosecutor will not have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Repeat.
Yes, ma'am.
How do you plead to criminal trespass and willful obstruction of an officer?
2 guilties. Guilty.
To willful obstruction, count 2, the sentence will be time served of 34 days with a credit of 17 days. For count 1, criminal trespass is 12 months to serve 34 days, credit for time served 17 days, balance suspended. So your obligation for this case is over. Once you are released, you are to stay away from the Walmart at 4735 State Route 138 in Union City, Georgia. Thank you.
Thank you, Judge.
Your Honor, if I have some other business I need to attend to briefly, if I may be excused, Ms. ASG Tucker will be handling the remainder of my cases.
That's fine. Thank you very much. Ms. Tucker?
Thank you.
Okay. Next case, please. Did ACDC have another case or?
What position is that? This is position number
14.
14?
Judge, number 14, Donnie Mims. It's going to
Yes.
be the negotiated plea.
Did you say negotiated plea?
I'm sorry, Judge.
Did you say negotiated plea?
Yes, Judge. The only request I have is as far as a fine, a reduction in fine in light of the amount of time they spend in jail. And I apologize, Mr. Stasnik, for that. But other than that, we're in agreement, Judge.
This is a $600 fine. Is this, let me see,
Might be mandatory.
40 hours, one victim impact panel. Is this his first DUI in 5?
I'm checking. So if I ask for 40,000, it's most likely, or excuse me, if I ask for 40 hours of community service, it must be a first in 5. However, if I ask for an elevated fine, I'm assuming that he does have another, yes, he has a DUI arrest out of 1991. So yes, he does have a prior DUI.
But that's not the statutory minimum, right?
Correct. It's so statutorily, the minimum is 300 because it's a first in 10. But
Okay.
lifetime, that's why I recommended the $600 fine, and that's what I would be recommending today.
Mr. Haddad, I'll be glad to reduce it to $300 fine, but the community service gets bumped up to 80 hours.
Yes, Judge, we're good.
All right. Any objection from the state?
No, I would just like to read the entire sentence as I understand it for the record. So it's going to be 12 months to serve 34 days, credit for time served 17 days, balance probated, to complete the alcohol drug evaluation and any recommended treatment, complete the risk reduction course, pay a $300 fine, complete 80 hours of community service, and 1 victim impact panel. That drug-related objects charge will be time served. Is that correct, Judge?
That's what I've got, correct.
Sounds good. Yep.
Okay. So, Mr. Donnie Mims, you're accused of driving under the influence of alcohol and possession and use of drug-related objects in case 25 CR 866C. You've been advised of your rights and your attorney is Mr. Haddad. For the purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
We stipulate, Judge, and request the modified state or the court's recommendation, Judge. Thank
All right.
you.
Mr. Mims, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your legal services?
Yes.
Oh, you're getting softer and softer. I don't know. I
Yes.
can't. Okay. Folks, this proceeding is being recorded, so you need to speak up so that we can record these pleas. All right. And also we have a court reporter who needs to hear what you are saying. Mr. Mims, if you decide to enter this plea to a DUI conviction, this will have a negative impact upon your driving history. Your driver's license will be suspended, and it could have an impact on any professional licenses you may have, on your residency if relevant, and it could also have an impact on any other open cases and your job. Are you still willing to move forward?
Yes.
All right, and you understand that if you plead guilty to these charges, you would have to give up your right to a trial in front of a judge or a jury. You will not get a chance to confront your accuser, challenge evidence brought against you, present your own defenses and arguments, and the prosecutor will not have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to driving under the influence of alcohol?
Yes.
How do you plead to possession and use of a drug-related object?
Yes.
For the drug-related object, that's going to be to serve 34 days, credit for time served 17 days, and that's a time served plea. For the DUI, it's going to be 12 months to serve 34 days, credit 17 days, balance probated. If you have no other cases holding you, you will report to Fulton County Probation on Monday, March 10th, before 3 p.m. While on probation, you will complete the following. And within 30 days of being released, you will enroll in an alcohol and drug evaluation and submit yourself to any treatment that's required by the evaluator. You will complete a risk reduction program within 60 days of being released. You will pay a $300 fine plus your probation fees and you will make a minimum payment of $50 per month. You will complete 80 hours of community service, and that will be done at any nonprofit agency that is not a church and not a school. And you must do a minimum of 10 hours per month. You're also to attend and complete one victim impact panel. You are not to consume any alcoholic beverages and no illegal drugs while you are on probation. You will be subject to random screens by probation. So please keep that in mind, that you can be called at any time to take a screen for alcohol and or illegal drugs. Thank you.
Thank you, Judge. Judge, may I inquire for the paperwork, who do I need to send it to? I'm sorry if I missed the chat.
No problem. April.champion at the Fulton County email.
Sounds good. Thank you.
Courtroom 2, next case.
Yeah, position number 3, Mr. Oliver.
Okay. Is that on the add-on?
Yes, I'm sorry, yes, on the
Judge,
add-on.
it's add-on.
Yep.
Your Honor, that's gonna be a negotiated plea, Judge.
Okay.
Good morning.
Good morning. This is State versus Keith Oliver, case 25 CR 781H, accused of 2 counts of theft by taking, criminal trespass, loitering, and prowling. Mr. Oliver, you've been advised of your rights. Your attorney is Mr. Haddad. May I place you on oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Head Tucker, what's the recommendation?
Yes, Judge. Mr. Oliver will be pleading to count 1, theft by taking, with the terms 12 months to serve 60 days, credit for time served 22 days, balance probated, to complete an anti-theft course, to have no further contact with Richard Crowder, and to stay away from all Georgia Tech property. On counts 2, 3, and 4, it will be 12 months probation concurrent with count 1.
Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
We stipulate, Judge, we ask the court to follow the state's, the negotiated plea. I would only ask if the court would be willing to waive the first 2 months of probation fees. He's gonna have to do another 8 days or so in custody. And of course, there's a cost involved with the class judge. So I would just ask to waive the first 2 months.
Would that be correct? I've got 12 months to serve 60 days. Credit for time served 22. Oh, yeah, you might be. Yeah, 8 more days. You're correct. Is this the theft of the bicycle, Ms. Tucker?
Yes.
And how many cycles does Mr. Oliver have?
Let me pull it up. This was one of Shelley's cases. So he has
I'm sorry, Ms. Tucker, I just recollect this case.
Okay.
I believe he had an $8,000 surety bond. And this was a repeat offense, if I'm not mistaken. Yeah, 46 cycles, multiple thefts since 2020 to the present time.
correct.
No, Mr. Haddad, there will be no waiver. He'll be required to report, once he completes this, he'll be required to stay 500 yards away from all Georgia Tech property, which means that it'd probably be completely staying quite far away from the downtown area.
Understood, Judge, and I just want to be clear, I was not asking to place him on non-reporting, I was asking
No,
for.
no waiver.
Okay, understood, okay, that's
Gonna
fine.
have to he needs to go get a job, a legal job, and start working and paying these fees and so 40. I remember this case because there were numerous incidences of thefts at the same location.
Understood, Judge. We're ready to proceed with the plea.
All right. Mr. And you so stipulate, right, Mr. Haddad?
We do, yes, Judge.
Mr. Oliver, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Perfect. Yes, ma'am.
And are you satisfied with your legal services?
Ma'am, yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to go back to a courtroom to face your accuser, challenge the evidence brought against you, be able to present your own legal defenses, arguments, and mitigating factors, and the state won't have to carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And you understand that by pleading guilty to these charges, you will be adding to your criminal history record, which was at the present time, as you know, quite extensive.
Yes, ma'am.
All right, as long as you understand that. How do you plead to 2 counts of theft by taking, criminal trespass, loitering, and prowling?
Guilty.
On
Guilty.
count, all right, thank you. On counts 2, 3, and 4, it will be 12 months probation concurrent with count 1. On count 1, it's going to be 12 months to serve 60 days, credit for time served 22 days. You have 8 more days to serve at the Fulton County Jail. Once you've served those additional 8 days, and if you have no other holds, then you'll be released, and you must report to probation immediately on the first Monday, Tuesday, or Thursday upon your release. While you're on probation, you will stay 500 yards away from all Georgia Tech property. As you know, they have quite a bit of extensive property in the downtown area, so you have to be very careful that you keep that 500-yard buffer. You are to have no contact with Richard Crowder, and within 60 days of being placed on probation, you will enroll and complete an anti-theft class. For the first 6 months while you are on probation, you will report twice a month. Do you understand, sir?
Yes, ma'am.
But you'll only be required to pay a monthly probation fee. If you have no problems during the first 6 months, then your probation will be reduced to once a month. Thank you.
Or visitation or what payment?
The visitation.
Visitation? Yeah, okay, all right. Okay. All right.
I
Twice
explained
a
it.
month in the first 6 months, and if you have no issues, you're not arrested again, you don't violate the no to stay away, and you complete your anti-theft class, and then you will be reduced to once a month visitation with probation.
Thank you, Judge.
Thank you.
Next, we have position number 16, Mr. Michael Thompson.
Your Honor, that would be a negotiated plea as well, and we waive reading of the charges. And
All right, sir. This is State versus Michael Thompson, 25 CR 888J. Mr. Thompson is accused of battery of a particular nature, and Mr. Thompson, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. This is going to be a negotiated plea. May I place you under oath? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Tucker, we will refer to the program as SDET.
Yes, Judge. The sentence recommendation is 12 months to serve 32 days, credit for time served 16 days, balance probated, to complete that SDET, complete 40 hours of community service, to have no further contact with Mariah Zachary, and to stay away from Publix at 950 West Peachtree Street in Atlanta.
Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
we stipulate, Judge, and we request that the court follow the negotiated plea, Judge.
All right. Mr. Thompson, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yeah, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial. Hello? Do I have your attention?
Yes, ma'am.
Oh, okay. I was saying that if you decide to enter this plea, you would have to give up your constitutional right to a trial. You will not be able to face your accuser in a courtroom in front of a judge or a jury, to be able to challenge the evidence brought against you, present your own arguments and defenses through your attorney, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the misdemeanor offense brought against you?
Dead and wrong. I mean, guilty or not guilty? Guilty.
I'll accept your guilty plea. Your sentence is 12 months to serve 32 days, credit for time served 16 days.
Yes, ma'am.
The remainder of the time you'll be on probation. You will report to probation on Monday, March 10th before 3 p.m. While on probation, you will complete the program we refer to as SDET. You must enroll in that program within 60 days of being released, and you must start on that program diligently without skipping any classes. You're to complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will do your community service at a minimum rate of 5 hours per month. At all times, you're to stay 200 yards away and not contact Maria Zachary. And you're to stay 200 yards away from the public store at 950 West Peachtree Street in Atlanta, Georgia. Thank you.
Can we do position number 2, Mr. Drake, and he's Miss McLeod's client?
Miss McLeod is here. All right, thank you. Good morning, Miss McLeod.
Good morning, Your Honor.
All right. And are we ready to proceed with Calvin Drake? Miss McLeod?
Yes, Your Honor, I am.
And what are we doing this morning?
I was hoping that we could modify my client's bond, Your Honor.
Okay, just give me a moment to pull that case up. This is on our add-on calendar. Sorry, we have, the add-on is almost as large as the main calendar. So this is Calvin Drake, accused of simple battery family violence from January 28th of this year. Case number 25 CR 594Y. Mr. Drake, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and currently representing you is Ms. Maureen McLeod. Ms. McLeod has already waived arraignment, so the case is further notice for trial. And as far as I can tell, this case is assigned to Judge Fred Eady, and I guess he got a bond at his first appearance on February 6th, and that was for $2,000 surety bond, no contact with Rotanza Phillips, and stay away from Stokes Avenue.
Yes, Your Honor, and then you had reduced it to a signature bond, but you had put a caveat on there for an ankle monitor. And the issue is my client just cannot afford the ankle monitor fees.
This is Calvin Drake for 25 CR 594Y.
Yes, Your Honor.
Maybe I'm missing it. Did I enter an order for an ankle monitor?
No, Your Honor, you announced that you would, and that if his bond could remain the same, or he could have a signature bond with the ankle monitor. We would really like for him to have the signature bond, Your Honor. He just can't afford the ankle monitor. And he's still in medical, as you can see, Your Honor. I went to see him on Saturday at the jail, and he was able to show me he still has significant bandages all around the torso area. And this incident happened well over a month ago. So he was in pretty poor shape after he came out of Grady and was taken to the jail.
Okay. Ms. Tucker, I only have Judge Morrow's order and possibly there was a, I'm so sorry, Ms. McLeod, but I have no recollection of that.
That's something, Your Honor.
Okay.
Going on.
Do we have
Yes.
the cycles, please?
Do we have pretrial on, or would you like me to give you the
I
history?
think pre-trial, yeah, Ms. Washington's
Here.
present. Yes, Ms. Washington, this is position 2 on the add-on calendar.
Yes, Your Honor. There are 6 arrest cycles out of New York, 7 arrest cycles with the federal government, and 28 cycles in Georgia. In 2024, there was a felony conviction for possession of a firearm by a convicted felon, and then a separate 2024 felony conviction for possession of a firearm by a convicted felon. There was also a 2018 misdemeanor conviction for battery. My computer is freezing up. And then a 2010 misdemeanor conviction for battery and 2 counts of robbery.
Okay.
And my computer is frozen, but
That's
that's what I have
sufficient.
so far.
Ms. Tucker, there is a request to amend it to a signature bond, and now I can understand why I would require an ankle monitor at this time. Ms. Tucker?
Yes, Judge, you've heard that history as well as these facts. They allege that he struck his ex-girlfriend. She wanted him to move out of the house. She was called the police. She didn't know she needed, to go through the proper eviction process, but he got mad that she called the police and he struck her. This is not the first time that he struck her. And so we're fearful for her safety, especially considering his history with her, that she told the police, that she told us, and that his criminal history shows us. So if you are willing to amend it to a signature bond, I would ask that you stick to your guns and require that ankle monitor. Otherwise, we'd request that the bond remain the same.
I'm just trying, I'm so sorry. If you please hold, I have an ag assault and aggravated battery in which he was given a signature bond on May 9th, on November 3rd, 2018. And that's what, November 2018. Less than 6 months later, no, literally 6 months later, on May 18th, he got booked in while on a signature bond for simple battery family violence. And then he doesn't seem to be a good candidate for a signature bond, Ms. McLeod. He presents a very high likelihood to reoffend.
He does not have anything concerning any batteries or anything like that since 2018. And I would like to explain the circumstances of this particular charge, Your Honor. What he's charged with simple battery, not battery. And what happened, from what my client told me, was that the alleged victim had a knife. And when he saw the knife in her hand and she was coming towards him, he just kind of pushed her hand away with the knife. And he ended up being stabbed. She stabbed him. That's why he's still in medical. He had to go to Grady. He spent over a week in Grady, Your Honor, and he's still in medical at the jail. And he's been at the jail now ever since he came from Grady Hospital over a week ago. They do not live together or anything like that. This was a situation where she had agreed that he could come there because he had a probation. My client, as the state mentioned, he had a charge about a convicted felon with a firearm. He had this firearm and shot himself in the hand. So his hand is pretty much useless right now because he shot himself in the hand, and that was the basis of that particular charge. That is what happened. I just want full clarity here. It wasn't like he was out committing a crime with this firearm. They did not live together. When he was actually being held on the gun charge, she called him and asked him to come to Atlanta to stay with her, and they agreed that he would stay with her. Then when she decided, okay, she didn't want him to leave, you know, he could have left, but she got angry, I guess, when the police would not evict him on the spot, and she came at him with a knife. And it is undisputed that he got stabbed up. You know, that is not in dispute at all, because his injuries are clear. He went to Grady, he had surgery. He was there for over a week.
And Judge, this is not a dual arrest.
Request denied.
No, I didn't say it was.
Ms. McLeod, I've read the warrant. I understand your client's position, but there is a completely opposite view also in the warrant. So if you would like to consider a motion, I highly recommend that you schedule a hearing with the division judge, Judge Edie's office, and have a motion hearing where the victim can be subpoenaed, and y'all can do this in person. Mr. Drake will be produced from jail and transported to Judge Edie's chambers, at which time then the judge will also have an opportunity to observe him. But at the present time, it is too one-sided for me to consider otherwise, given his criminal history record, given the allegations set forth in the warrant, where it doesn't, there are issues based on Mr. Drake's version of events that don't coincide with the allegations set forth in the warrant.
I understand, Your Honor, but given the fact that he's indigent, even if it's not that we object to the ankle monitor per se, we're just saying that he can't pay for it. If there was a way that the ankle monitor, he could have it for free, we would be fine with that. He just can't pay for it. And it just seems like that's a fundamental right of his.
No, it's not a fundamental right, Miss McLeod. It's not. He
Well,
has.
Your Honor, I'm saying it's because he's poor why he can't get out of jail. Because had agreed and told me that I could talk to him and see.
Are you willing? Is he willing to pay for the ankle monitor?
He can't afford it, Your Honor. That's the issue. He just can't afford it.
Back to the original agreement, a $2,000 bond. He has a $2,000 bond based on the Ayala factors. He has a significant violent history. He's got multiple felony convictions. He demonstrates a high likelihood to reoffend, and he poses an imminent threat to the victim. Based on the allegations set forth in the warrant, it's inconclusive as to whether the stabbing was a self-inflicted wound or whether the victim allegedly struck him. And if it's the latter, then there is an issue of whether it was done in self-defense or whether she was the first aggressor. Too many questions up in the air. The request for a bond modification is denied. Thank you, Ms. McLeod.
Thank you, Your Honor. That concludes my business before the court. May I be excused?
Yes, thank you.
Have a great
We
day.
got one other conflict. Is he your Ms. McLeod, Mr. Walter Price? He's your client?
Mr. Price, no. The issue with Mr. Price is that the alleged victim in that case
Walter Price?
is I formerly represented.
I see.
Okay. Yes. Carlos Peterson is a former client of mine.
Okay. And
so I can't represent.
Okay. And Mr. Haddad? Thank you, Ms. McLeod. Did you have any other cases this morning, Ms. McLeod?
I do not, Your Honor.
Okay, thank you.
You're
Mr.
welcome.
Haddad, we have Walter Price at medical, position number 4 on our add-on calendar. And he was represented by Conflict Maureen McLeod, who has to now conflict herself out because she represented the victim, Carlos Peterson. So Mr. White, do you either one of you know why the PD's office conflicted themselves out?
Judge, if you'll give me a second, I can find out.
Okay.
And Your Honor,
go ahead.
This announcement was made Tuesday, so
Okay.
there could have been a conflict assigned to him by now.
That is correct, Your Honor. I did indicate on Tuesday that I was unable to represent him because I had previously represented Mr. Peterson.
We will try to see if we can get Dennis Murphy to come in to the Zoom session to speak to Mr. Price, but otherwise, I think I will appoint Dennis Murphy. Was an appointment made on Tuesday? Do you recall, Ms. McLeod?
No, Your Honor, what was said that they would try to find a conflict attorney to represent him.
All right. Medical, I'm going to see if attorney Dennis Murphy can join us on the Zoom. Otherwise, we're going to have to reset it to next Tuesday, pending Mr. Murphy's interview with him. All right. Thank you. If you have, okay, that's good. Quorum 2, who do we have?
Position number 5, Mr. Gang.
Position number 5. And going to the main calendar, and what was that name again, please? I can't.
Dominic Gay, Your Honor.
Dominic Gay, okay. This is State versus Dominic Gay, accused of criminal trespass from February 21st, 2025, 25 CR 0000912Y. Mr. Gay, you've been advised of your right to remain silent, and your attorney is going to be Mr. White. And Mr. White, this is going to be a plea?
It is, Your Honor.
All right. Mr. Gay, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Tucker, what's the recommendation for position 5, Mr. Dominic Gay?
Yes, Judge. Mr. Gay will be pleading to criminal trespass with the terms 12 months to serve 26 days, credit for time served 13 days, balance probated, to complete a BHET, and to stay away from the Citgo gas station at 2000 Delau Drive in Atlanta.
Mr. White, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
Mr. Gay, I'm not sure did I place him under oath? No, I didn't. Do you raise your right? Did I place you under oath, Mr. Gay? No? Oh. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Sir, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes.
And you've spoken to your attorney about accepting this plea in exchange for a guilty plea. Was it explained to you that if you do that, you would have to give up your right to a trial? You will not go back to a courtroom to face a jury or a judge, to challenge the evidence brought against you, to confront those accusing you of this charge, and to have this prosecutor prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Can I ask you a question?
Sure.
So I won't be released today?
If you have no other holds.
Yes, as we discussed yesterday, you'll be released within the next 24 hours. It'll probably be tomorrow morning, but potentially late tonight.
All right.
Okay. So, did you have any other questions?
No, ma'am.
How do you plead to one count of criminal trespass?
Yes.
Sorry?
Yes.
Was that a guilty?
Yes, ma'am.
All right. Your sentence is going to be 12 months to serve 26 days, credit for time served 13 days. You'll be released within 24 hours, which means it'll either be early Friday morning or later on Friday morning. But on Monday, March 10th, before 3 p.m., you must report to the Fulton County Probation Office. And the probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you have to stay away from the Citgo gas station at 2000 Delau Drive in Southwest Atlanta. Do you remember the Citgo gas station?
Yes, ma'am.
You cannot be on its property. You cannot be on the parking lot, at the gas station, in the store, or even on the sidewalk. Do you understand?
Yes, ma'am.
And within 60 days of being released, you must complete a BH evaluation and submit to any treatment or counseling that's required.
Okay.
And Your Honor, we request that probation go to non-reporting once he's completed that requirement.
Any objections from the state?
No objection, Judge.
All right. Mr. Gay, once you've completed your evaluation and any and all treatment and your probation fees are up to date, then your probation will be non-reporting. But until then, you'll be required to report once a month.
All right. Thank you.
Thank you.
Thank you, Your Honor.
Honor, if I may,
Yes, Mr. Haddad?
Your Honor, the court inquired as to why we conflicted out of Walter Price. He was conflicted out of SEA. The reason is this is a jail incident, and we actually represent the alleged victim on felony charges. So that was the basis of. So the victim is the alleged victim is a client of ours at the Fulton County Jail, felony charges.
All right.
That was the basis.
Okay. Let's see if Mr. Murphy can join us. Thank you.
You're welcome, Judge. And then
Okay. Next case in courtroom 2.
Your Honor, position number 1, Jeremy Caldwell. Your Honor, I had initially indicated yesterday that this is going to be a not guilty, but he was brought here. I spoke to him. I made the I told him what the recommendation is. He wishes to enter a plea as a negotiated plea, Judge.
Okay. Is he present? Oh, there he is. Okay. This is going to be position number 1 on the calendar, and State versus Jeremy Caldwell, case number 25 CR 890G. Mr. Caldwell is accused of battery, family violence, obstructing or hindering a person from making an emergency phone call, and criminal trespass causing damage to property. Mr. Caldwell, you have been advised of your right to remain silent, and your attorney is Mr. Haddad. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
No.
Repeat.
Yes.
Thank you. Ms. Tucker, do you have the recommendation for Mr. Caldwell?
Yes, Judge. Excuse me. Mr. Caldwell will be pleading to count 1, battery, family violence. That's going to be 12 months to serve 90 days, credit for time served 15 days, balance probated, to complete the family violence intervention program, to have no further violent contact with Jamisha Getter, and to stay away from the Super 8 Motel at 3701 Jonesboro Road, as well as to have no firearms on probation. Counts 2 and 3 will be 12 months probation concurrent with count 1.
And Mr. Haddad, are these the terms to which your client has agreed? And do you stipulate to the factual basis, venue, and ID?
Yes and yes, Judge.
All right. So I understand that he received a signature bond through pretrial, but does he have any other holds?
Your Honor, I believe he does have a hold, felony hold, Judge.
Okay, so he will need to report to probation when he is released from that hold.
That is correct. He'll have a minimum, another 30 days on our case, the misdemeanor case, if my math is correct, Judge. He has a probation hearing scheduled for the 28th of March. And is obviously assuming he gets time served on that, then he'll report when he's released, Judge.
Okay, so as long as we're on the same page, he has another minimum stay of 30 days at the jail. And then if the hold is also off, then he can be released to report to probation. Would that be correct?
That's correct, Judge.
Okay. Mr. Caldwell, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
And has it been explained to you that if you decide to plead guilty to battery family violence, that this will be a conviction on your record? Any subsequent arrest for a similar offense can be a felony charge. Has that been explained to you?
Yes, ma'am.
All right. Are you still willing to move forward with this plea freely, willingly, and knowingly?
Yes.
So you know that if you plead guilty to these charges, you would have to give up your right to a trial. You will not have a hearing before a judge or a jury. You will not go back to court to confront your accuser, challenge evidence brought against you. The prosecutor won't have to prove the charges beyond a reasonable doubt, and you won't get a chance to present your defenses and arguments. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence, obstructing or hindering a person from making an emergency phone call, and criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 90 days, credit for time served 15 days. You have an additional 30 days to finish at the Fulton County Jail. Once you are released upon completing your 30 days and released from any holds, then you will report to probation on the first Monday, Tuesday, or Thursday immediately following your release. And you must report before 3 p.m. While you are on probation, you are to have no further violent contact with Jamesia Jeter. You are to enroll within 45 days of being released in a domestic violence intervention program, and you must complete all 26 classes without missing or skipping any of those classes. At all times, you're not allowed to own, possess, or have any firearms near you. On counts 2 and 3, it will be 12 months probation concurrent with count 1. Thank you.
Thank you, Judge. Thank you.
Wow.
Can we do, position 5, Gregory Rice?
All right, this is on the add-on calendar, and Gregory Rice. Mr. Who is representing Gregory Rice? He's at the medical unit. Mr. Gregory Rice is accused of battery, family violence, battery from a February 13th, 2025 incident under case number 25 CR 784E. Mr. Rice, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And this is the oh, here we go. Mr. Rice is represented by Mr. Haddad. Mr. Haddad, well, let's see, first of all, Ms. Tucker, has there been any update on the transfer of this case to the district attorney's office?
And no, Judge, I believe the case is going to stay with us. However, I do have an announcement. The state will be filing a motion to revoke bond by the end of the day based on jail calls that we've recorded where this defendant is explicitly coercing the victim to drop the charges. I believe that's a violation of Maine Ayala factor. So we will be filing that motion to revoke bond to be heard whenever proper notice is given.
All right, Mr. Haddad, how would you like to proceed in this case?
Well, Judge, I mean, I've not talked to Mr. Rice only because my understanding was going to be a DA transfer. I mean, we'll ask to reset it for next week. I'm not really sure right offhand what's keeping him in custody. If it's something else or not, I don't know right off.
Gregory Rice, correct?
Right, that's correct.
Okay. So, I guess they're keeping the case. So either the DA's office declined it or something else happened, but I'm not certain. But they're staying with state court as a misdemeanor. He's got a bond for $2,500 surety bond granted on February 14th of this year. And the case is going to be further noticed for trial. And Ms. Tucker, if the state decides to file a motion to revoke bond, then that matter may be addressed by Judge Morrison, who is the division judge over this case.
And Judge, I guess, never mind, Judge. That's
Hey,
fine.
Mr. Hurday, can we do a breakout with you so you can explain to them what's going on?
Sure. I mean, Ms. Tucker, is there an offer on the table?
Yes,
If you wanna
I'll
say-
read it out to you real quick. So count one, the battery family violence would merge with count two, battery. It'd be 12 months to serve 180 days, credit for time served 22 days, to complete an MHET, as well as to have no further contact with Asia Arnold and to stay away from 2905 Springdale Road.
All right. Judge, if we can do a breakout room on my computer, I'd be happy to speak to Mr.
All right. I'm just a little perplexed. They're going to file a motion to revoke, but they're willing to do a plea. So that's up to the state. Okay. Once you get on your laptop, Mr. Haddad, Miss Hawkins will put you and medical into, Miss Grace will put you and medical into a breakout. Medical, please hold for the message on the screen. All right, Miss Grace, please place PD Attorney Haddad and medical into a breakout.
Yes, ma'am.
Thank you. Mr. Chate, do you have any clients ready to address in courtroom 2?
No, Your Honor, we're gonna be on recess because we're bringing down the inmates from the floor.
Okay. All right, Mr. Haddad's going into a breakout. And while we are sort of in a constructive recess, Mr. White or Mr. Chate, do you want to go over your clients' cases just to give me a status? Mr. Chate, do you want to go over your cases right now?
Yes, Your Honor.
All right. So positions 1, 2, I'm on the main SAP calendar. Positions 1, 2, and 3 will please. Terrell Gaskin, is that your client?
It's not my client, Your Honor.
It's mine, Judge.
All right. Terrell Gaskin is going to be reset to March 13th. Is that correct?
That's correct, Judge. We were told he was loaned out, but we're not sure where. So we'll try
Okay.
again.
All right. Positions 5 and 6 will please. 7 was a plea. 8 and 9 will please. 10, Eric Jones, and that is Mr. Chate's plea. Case that will be a non-negotiated plea.
Yes, Your Honor.
Position 11, Leon, is going to be a plea. 12, Malaku is going to be a plea. Position 13 is Mr. Chate. And have you had a chance to speak with him? Terrace Milton?
I still need to speak with him, Your Honor.
Still need to speak, okay. 14, Mims was a plea. 15, Montori Rucker, and need to speak.
Minus the time that we've already done.
All right, 16, Michael Thompson, need to speak. Oh, Thompson was a plea, so that's over with. 17, Bond is, I guess it's going to be a waiver of arraignment. And that was do not bring. So position 17 is a waiver of arraignment and further notice for trial. Position 18, Nelson Witt, is released. So that's going to be further notice for trial. Okay. On our add-on calendar, position number 1 is Miss Tucker. Any update on the transfer for Lionel Carter?
Yes, Judge, the DA's office approved that transfer, so I'll be sending a transfer order to Ms. Champion.
All right. So position number 1 is transferred to Superior Court. Position number 2 is further notice for trial.
All right, I'll see you in a bit then, sir.
Position number 3, Keith Oliver, was a plea. Position number 4, is going to be, that's just pending to see if Mr. Dennis Murphy appears. Position number 5, Gregory Rice, Mr. Haddad was talking to him.
That'll be a plea, Judge. I'm sorry.
Go ahead, what will it be?
That's gonna be a negotiated plea, Judge, under the terms that Ms. Tucker mentioned.
All right, so we'll pause at this juncture. Ms. Tucker, is the state still moving forward with the plea offer?
Yes, Judge.
Okay. This is State versus Gregory Rice, 25 CR 784E. Mr. Rice has been advised of his rights, and he is accused of battery, family violence, and battery from February 13, 2025. Mr. Mickle, please. Mr. Rice, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. You may put your hand down. Ms. Tucker, what's the recommendation for Mr. Rice?
Yes, Judge. Count 1, the battery family violence will merge into count 2. Count 2, battery, the terms are 12 months to serve 180 days. Credit for time served 22 days. Balance probated. To complete an MHET, to have no further contact with Asia Arnold, and to stay away from 2905 Springdale Road.
And Mr. Haddad, does your client understand that he will be spending an additional 68 days?
Yes, Judge. Well, I did the math and I told them it would be 2 months and 2 weeks. I was off by a week. And Judge, the only, we stipulate to the factual basis. My only question, Judge, and I'm gonna ask the state to null process the family violence battle, because the merge, you know, I mean, if they're proceeding with battery, then it's a battery, not a family violence battery. And the merge, in effect, it should be a null process or dismissal. Because
I don't see an FVIP requirement. It's a MHET requirement.
No, I agree, Judge. But my point is, if we do a merger, I don't know how it's going to come up on a GCIC. In other words, heaven forbid, if he has another, let's say, he gets arrested on a family violence battery, you know, 5 years, it should be his first offense and not his second offense. That's what I'm trying to get clarification.
Ms. Tucker, I think it's cleaner if you do a null pros on the battery FE.
I'm looking into it. I understand his argument. I'm just checking the case real quick, the notes. Okay, I will submit the null pros.
Okay. Count 1 will be a null pros, and count 2 would be the charge to proceed on.
Thank you, Judge. Thank you, Ms. Tucker.
All right. So do you stipulate to the factual basis, venue, and ID, Mr. Haddad?
We do.
All right. And this is on the charge of battery. Mr. Rice, have you consumed any medicine or alcohol recently?
Medicine, you said medicine or alcohol, ma'am?
Medicine or alcohol recently?
No, besides the medication that I take.
Okay. After consuming the medication, are you still able to understand what's going on today?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, I'm very satisfied. Yes, ma'am.
If you decide to move forward and take a guilty plea for the charge of battery, you understand that you have to serve 68 more days at the Fulton County Jail.
Yes, ma'am.
That's about 2 months and 1 week, just over 1 week.
Yes, ma'am. I understand.
And if you decide to take this plea, you would have to give up your right to a trial. You will not go back to a court of law to face your accuser, challenge evidence brought against you, be able to present your arguments, defenses, and mitigating factors, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
All right. How do you plead to one count of battery?
Guilty.
Your sentence is 12 months, serve 180 days, credit for time served 22 days. As indicated, you have 68 more days at the jail. Once you've completed your 68 days and you are released, then you must report to probation immediately on the first Monday, Tuesday, or Thursday following your release. Understood?
Yes, ma'am.
While on probation, you will stay away from 2905 Springdale Road in Atlanta, Georgia, and you will have no contact with Asia Arnold. That means no more phone calls. You can't speak to her by mail or email or even in person, and you have to stay 200 yards away from her. Even if she invites you over, you have to say no because that's the court order.
Yes, ma'am.
While you're on probation, you also enroll and complete an MH evaluation, a mental health evaluation, and you must submit yourself to all counseling, treatment, and medication. Do you understand?
Yes, ma'am.
All right. And you must do that evaluation within 30 days of being released.
Yes, ma'am. Wait, where do I do the evaluation at? Or do I go to probation?
You can go to 10 Park Place, you can go to Grady Hospital, or you can go to whichever doctor you're comfortable with.
Yes, ma'am.
Thank you.
You're welcome.
All right. Yeah, so we had paused at position number 5 with Mr. Gregory Rice, and that is a plea. Position 6, Adriana Seagrave. What are we doing there?
Your Honor, we're resetting that case for next week.
All right, so reset to March 13. Position 7, Kevin Thompson is need to speak. You have a few that you need to speak. 8 to 12, Ernest York is considering.
Judge, they brought, I believe, Mr. Thompson and Mr. York just a second ago. I need to speak to them both.
Okay, all right. I think you have a few more cases, so so do you need to be in recess, or Mr. Chate, are we ready with any of your cases? Otherwise, you can mute courtroom 2 and we'll take a recess.
Perfect. Thank you, Judge.
Okay. All right, folks, we'll be in recess until courtroom 2 is ready to address the cases.
Your Honor,
Yes, sir.
we can go with position number 11, Mr. Lyons.
Okay. Keandre Lyons is accused of battery family violence from a January 27, 2025 incident. Accusation number 25 CR 450C. Lyons, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and presently your counsel is Mr. Chate. And Mr. Chate, how are we proceeding?
We're proceeding with the negotiated plea, Judge, and I just asked the court to consider having Mr. Lyons go on a non-reporting status after he completes the FVIP and the 80 hours of community service.
Ms. Tucker or Ms. Washington, do you have Mr. Lyons' GCIC? I don't know if I can pull that up right now. On the other calendar. Oh, okay. Position, Ms. Tucker, do you have?
Yes, Judge, I'm pulling it up right now. Uh, 5 cycles in Georgia. A conviction for battery family violence out of 2023 out of Clayton County.
Oh, that's good. Thank you. Request denied. Shall we proceed, Mr. Chate, or would your client like to enter a not guilty plea?
We'll proceed.
Okay. Mr. Lyons, if you decide to move forward with this plea, please understand that you'll be required to report every month until the remainder of the 12 months are completed. Are you still willing to move forward with this plea?
Yes, Your Honor.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Tucker, what's the recommendation?
Yes, Judge, it's going to be to battery family violence with the terms 12 months to serve 180 days, credit for time served 39 days, balance probated to complete the family violence intervention program, 80 hours of community service, to have no further contact with Alexander Wallace Robinson, and to stay away from the QT at 1678 Howell Mill Road in Atlanta.
Mr. Chate, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He accepts the terms, then I stipulate.
Okay. Mr. Lyons, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, I am.
If you decide to enter this plea, you understand this will be a what appears to be your second battery family violence conviction on your record.
I understand.
Any subsequent arrest for similar offenses can be a felony charge. Are you still willing to move forward?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial. You would not be able to go back to court to confront your accuser, challenge the evidence brought against you, present your own arguments and defenses through counsel, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to one count of battery family violence from January 27, 2025?
Guilty.
Your sentence is 12 months to serve 180 days, credit for time served 39 days. I didn't do the math, but somebody wants to tell me how many more days he has to serve in jail. I have 56 more days. Is that correct?
I have 51 days, Your Honor. I divided the 180 by 2 and then just subtracted the credit for time served days.
180 minus 68?
No, so I divided the 180 by 2, so
Oh,
that's 9.
78. Yeah, that's where I messed up. So it's 101?
No, 51 more days.
51. Okay. Yeah, sorry. 51, 50, 102. Yeah. I'm going to rely on your math, Mr. Chate. So, so according to your counsel, Mr. Lyons, you have 102 more days to serve at the Fulton County Jail. Once you're completed with this time.
Your Honor, how did we get to 102?
No, because it's 51. I'm so sorry.
Okay.
I've got a paper riddled with numbers. Let me start again. Mr. Lyons, your sentence is 12 months to serve 180 days, credit for time served 39 days. You have 51 more extra days to serve at the jail.
I got you. Yeah.
After you completed the 51 days, and if you have no other holds, you'll be released, and you must immediately report to Fulton Probation on the first Monday, Tuesday, or Thursday following your release. While on probation, you will enroll in a domestic violence intervention program, and you must enroll within 30 days of being released. It is very important you do it within 30 days. And you will attend and complete all 26 classes without skipping or missing any of them. You're also to complete 80 hours of community service And you can do that at any church or any school, but you must do a minimum of 15 hours per month. Do you understand? 1-5. Okay. No contact with Alexander Wallace Robinson, and you cannot return to the QT gas station at 1678 Howell Mill Road in Atlanta, Georgia. Thank you.
Thank you.
Position 5, Milton.
And that was the one where we were waiting on Mr. Murphy. Medical, would that be correct? No, that was not the one.
Is that the 11 o'clock calendar?
Medical?
I think it may be number 13 on the regular calendar. Milton.
All right.
Yeah, I'm sorry, number 13. I am so sorry.
No problem. All right, Milton is Mr. Haddad's client, and he needs to speak with him. Or is it Mr. Chate?
Milton is my client, Your Honor.
All right. Mr. Chate, do you have a device that you can sign on so we can put you into a breakout? Or can you use Mr. Haddad's?
Yes, I have my laptop, Your Honor. I can get on the Zoom right now.
Okay. Miss Grace, as soon as Mr. Chate is on his laptop, please place medical and him in a breakout.
Yes, ma'am.
All right. Yes, Mr. Haddad?
I do have one announcement ready for a plea on Mr. York, Ernest York. He's on the add-on position 8 through 12, I think.
Through the end of the calendar, yeah.
I'm sorry. I apologize.
That's okay. 8, 9, 10, 11, 12. Yeah, that's that would be correct.
Your Honor, this is going to be a negotiated plea. There total, I believe, of 4 cases. He'll have an additional 15 days to do in terms of the custody portion, Judge. But other than that, we're ready to proceed as a negotiated plea, Judge.
All right. I'm just Miss Grace, you got the one for medical and Mr. Chate?
Who laptop is he signing into?
I believe it's going to be his own. So you will.
Okay, he just coming on now, man.
Oh, okay, great.
If you want to, yeah, just in the hallway or, you know, by the restroom.
Gosh, sorry, I'm so sorry. Because we've got multiple calendars. I just need to make sure I'm on the right one. And this is on our add-on. Okay. All right. Ms. Grace said, whenever you're ready, you can put them in a breakout. This is State versus Ernest York. Mr. York has 1, 2, 3, 4, 5 cases on our add-on calendar, positions 8 through 12. And 21 CR 102G. He's accused of simple assault from August 20th, 2019. 23 CR 5653E. He's accused of 2 counts of simple battery from June 14th, 2022. 25 CR 907G. He's accused of following too closely and hit and run, failure to return to the scene of the accident from June 23rd, 2022. He's got a bench warrant, 25 FTA 372 from March 22nd, 2024. And the 5th case is 17 CR 126493. In which he's accused of failure to obey traffic signs, signals, and markings, and driving without a valid license from June 22nd, 2015. All right, Mr. York, you have a right to remain silent. Anything you say, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Haddad for all these cases. This is going to be a plea hearing. Mr. York, please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am, I do.
All right. Ms. Tucker, I believe there is a universal offer is listed on position number 8 for all the 5 cases.
Yes, Judge. In position 8, 21 CR 0000102G, on that simple assault, the terms will be 12 months to serve 60 days, credit for time served 15 days, balance probated, to complete 12 weeks of anger management, complete 40 hours of community service, and have no further contact with Jamil Abdul Karim. On the next case, 23 CR 005-653E, the simple battery count 1 will be 12 months to serve 60 days, credit for time served 15 days, balance probated, all to run concurrent, 12 weeks anger management, 40 additional hours of community service, to have no further contact with Anthony Allen, and to have absolutely no firearms while on probation. That second simple battery will merge. On the third case, 25 CR 000-907G, the failure to the traffic offense will be 12 months to serve 30 days. Credit for time served 15 days, balance probated with a $150 fine. The hit and run will be 12 months to serve 30 days, credit for time served 15 days, balance probated with a defensive driving class, as well as a $500 fine. Those are all to run concurrent. And on the 17 CR 012-649C case, the failure to obey traffic signals will be time served. The driving without a license will be 12 months to serve 30 days, credit for time served 15 days, balance probated with a $500 fine. That FTA case will be null prost.
All right. Oh, boy. I'm trying to keep up with all the fines, but I'm just going to rattle it all off just as you did. Okay. Mr. Haddad, does your client accept these terms in the 4 cases? And do you stipulate to the factual basis, venue, and ID for all 4 cases?
Judge, we stipulate for purpose of the plea, would ask the court to follow the negotiated plea, and what I've explained to Mr. York, under the terms, he'll have an additional 15 days in custody. Once he's released, he'll have to report to probation as instructed by the court, and he'll have 12 hours anger management, 80 hours community service, and of course, a fairly substantial fine, but he does have the period of probation to pay that.
$650 fine. And I have $1150 in total fines. Would that be correct?
That is correct, Judge. And under that, Judge, I would just respectfully request to waive the probation fees, at least for the first 2 months.
I will waive the probation fees for the first 2 months,
Thank you, Judge.
as long as he complies with all the conditions.
Thank you, Judge.
All right. So, Mr. Thompson, have you consumed any medicine or alcohol recently?
Your Honor, I believe Mr. York, I apologize.
I'm sorry, Mr. Thompson's case is right above that. Sorry about that. Okay, Ernest York. I've got your name right. Mr. York, have you consumed any medicine or alcohol recently?
Oh, man, my med regular from the doctor.
You have what?
My meds this morning, that was it.
All right. Did you consume some medicine recently?
Did you take some medicine this morning? Yeah, this morning, Judge.
Okay.
Does it
I
affect
just need to know whether you can understand what's going on in all your cases.
Yes, ma'am, I do.
Okay. And are you satisfied with your attorney?
Yes, ma'am, I am.
Now, these are a lot of cases and quite a bit of fines and a lot of programs to do. Are you willing to move forward with this plea offer and comply with these conditions?
Ma'am, I am.
Okay, and you understand that driving points will be added to your driving history, and it's possible that your license may be suspended if you have enough points on your driving history. So one of the charges is driving without a valid license, which will trigger a license suspension.
Okay. She's just telling you made it.
Yes, ma'am.
All right. If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not go back to court. You won't be able to face your accusers, to be able to challenge the evidence presented against you in all these 5 cases, to be able to present your own arguments, defenses, and mitigating factors through your attorney. And also the prosecutor won't have to carry its burden to prove these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead? Well, let's start at the top. How do you plead to simple assault from August 20th, 2019?
Yeah.
I'm sorry?
Guilty.
Your sentence for that is 12 months to serve 60 days, credit for time served 15 days. You'll be on probation. While you're on probation, you will do a 12-week anger management program, and you must do that within the first 6 months of your probation term. You will also do 40 hours of community service at any nonprofit agency that's not a church and not a school, and you're to have no contact with Jamil Abdul Karim. In your second case, 23 CR 5653E, how do you plead to 1 count of simple battery?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 15 days, balance probated. Again, that 12-week anger management program will apply to this case, and you're to do an extra 40 hours of community service, which means right now your total community service is 80, which you will do at a minimum rate of 10 hours a month while on probation. Do you understand?
Yes, ma'am.
Okay. In addition to that, you're to have no contact with Anthony Allen, and you're not allowed to own, possess, or have any firearms near you while you are on active probation. In case 25 CR 907G, how do you plead to following too closely and hit and run, failure to return to the scene of the accident?
Guilty. Guilty.
Okay. Your sentence for following too closely is 12 months to serve 30 days, credit for time served 15 days, balance probated with an additional $150 fine. For the hit and run is 12 months to serve 30 days, credit for time served 15 days, balance probated. You are to do a defensive driving class and pay an additional $500 fine. The defensive driving class must be completed within the first 6 months while you're on probation. Your bench, then your last case is going to be 17 CR 12649C. How do you plead to failure to obey traffic signs, signals, and markings and driving without a valid license?
Guilty.
On the failure to obey signs, that's going to be time served to serve 30 days, credit for time served 15 days. On driving without a valid license is 12 months to serve 30 days, credit for time served 15 days, balance probated, a $500 fine. So your total fines are $1,150. You must make a minimum payment of $110 per month until your entire fines are paid off, including your probation fees. Your first 2 months of probation fees are waived, which means for the months of March and April, you don't have to pay probation fees, but you start paying probation fees from May 1st, 2025 onwards. No driving unless you have a valid driver's license, adequate insurance, and proper registration for the vehicle you operate. So as I said, driving without a valid license is a grounds for DDS to suspend your license. So do not drive until you've had your license reinstated, and you must make sure you have the registration and insurance. Thank you.
Thank you. All right. It's okay.
Mr. Haddad, have you spoken to Kevin Thompson?
No.
I don't believe he's been brought yet. Kevin Thompson? Kevin Thompson? Which one is you, Kevin?
Are we ready to go back to position number 13?
All right.
It's a mic. That's your case.
Yeah,
All right, Mr. Chate, how are we proceeding with Mr. Milton?
we're proceeding with the negotiated plea, Your Honor.
Okay, this is 25 CR 902F. Mr. Terrence Milton, you've been advised of your rights. May I place you under oath for your plea? You solemnly raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
All righty. Ms. Tucker?
Yes, Judge. Mr. Milton will be pleading to criminal trespass with the terms 12 months to serve 28 days, credit for time served 14 days, balance suspended, with a stay away from the Wesley on the Beltline Apartments at 370 Northside Drive in Atlanta.
Mr. Milton, is there a reason why you have that finger up?
I just got
Look at your finger. That's
I just got my calendar.
medical deputy. Yeah. You can put that piece of paper down. Thank you.
Look, she's starting out and sitting there to the one.
Mr. Chate, does your client accept the terms, and do you stipulate to the factual basis, venue, and ID?
I stipulate, Your Honor, no objection to the terms. I just asked for, I would just like to ask for a police escort so that he can retrieve his belongings from those apartments. My client informs me that he has some belongings there he needs to retrieve.
All right. It'll be a one-time visit with a police escort. All right. Mr. Milton, have you consumed any medicine or alcohol recently?
Yes.
And are you still able to understand what's going on in your case?
Absolutely.
Are you satisfied with your attorney?
Yes, I am very satisfied. Also with the jail. They did a very good job.
And are you entering this plea freely, willingly, and knowingly?
Absolutely.
In that case, if you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial before a judge or a jury. You will not get the opportunity to go back to a courtroom to confront your accusers, challenge the evidence brought against you, present your own legal defenses and arguments, and the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Again, I do appreciate the jail for taking care of me this time that I did serve extra. They did a very good job.
How do you plead to one count of criminal trespass?
No low contendere.
Denied. It's either going to be a guilty plea or we go to trial.
Guilty.
The sentence is going to be 12 months to serve 28 days, credit for time served 14 days. You have completed your jail time. If you have no other holds, you should be released within 24 hours. The remaining sentence is suspended, and you are to stay away from the location apartment complex called the Wesley on the Beltline, or the entire apartment complex at 370 Northside Drive in Atlanta, Georgia. You're permitted a one-time visit to your apartment unit, but you must be accompanied by a police officer, and you are allowed to go to your apartment unit one time only to retrieve your personal belongings. That visit cannot exceed 1 hour. Thank you.
You're welcome.
Judge, will Mr. Dennis Murphy be logging on for the other conflict?
The last message I got was that we called him and emailed him, and this was at 10:40 a.m. It's now 11 a.m. No, we won't. So we'll reset it to Tuesday, and that will be March 11th at 9 a.m. And hopefully Mr. Murphy will speak with him before that time.
All
Thank
right,
you.
thanks.
All right. Mr. Chate, did you have any other clients that you needed to speak?
I don't need to speak with any other clients.
Okay. And Mr. Haddad?
Judge, I have a couple announcements.
All right, let's proceed.
Judge, on the add-on, position number 7, Kevin Thompson, if we can reset him for next week, Judge.
All right, reset to March 13th.
And on position number 15, on the regular, Montori Rucker, if we can reset him for next week, we can find him. So he's at the jail somewhere. He's serving another sentence anyway, Judge, but I'm asking to reset it for next week.
Oh, that was 15. Okay, so that's reset to March 13th. What about Malaku, position 12?
He's present, Judge. I think that might be, yeah.
Yeah, he's fine.
But is that a plea?
Yeah,
We're ready for a plea on that.
that one's a plea, Your Honor.
Okay, and Eric Jones?
He's here too.
Mr. Jones, will also be a plea.
Okay,
Unnegotiated plea, sorry.
all right, so we can begin with, who do we have at the present time next to you, Mr. Chate?
Mr. Malaku.
Okay, this is Sinte Yahu Malaku, accused of criminal trespass causing damage to property from February 19th, 2025, case number 25 CR 884H. Mr. Malaku, you've been advised, well, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Chate. May I place you under oath for purposes of the plea?
Which hand?
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes. Well, yes.
All right, I heard you say yes, thank you. Ms. Tucker?
Yes, Judge. Briefly, Mr. Shatai, did he decide if he wanted to do the course or 40 hours community service?
40 hours community service.
Okay. All right. So he will be pleading to criminal trespass with the terms 12 months to serve 30 days, credit for time served 15 days, balance probated, to complete 40 hours of community service, and to stay away from the Legends Cafe at 5110 Old National Highway, Suite B in College Park.
All right. And Mr. Chate, do you stipulate to the factual basis, venue, and ID?
Your Honor, my client has a question. Let me confer with them.
Okay. Please mute the screen. Mr. Chate, please mute your screen. We can hear you. Thank you.
All right, we stipulate, Your Honor, we also just ask that if it'd be possible to place Mr. Malaku on a non-reporting status after he completes his 40 hours of community service.
After he completes the 40 hours of community service, is up to date with all probation fine fees and surcharges, then he may go non-reporting as long as he continues to stay away from the Legends Cafe. Mr. Malaku, have you consumed any medicine or alcohol recently? Okay. We have a court reporter who has to take down everything that's being said, and she cannot take down shaking head. So you have to say yes or no.
No, ma'am, I'm sorry.
And have you understood what's going on in your case?
Yes, I understand.
Are you satisfied with your attorney?
Yes, I'm very satisfied on his service.
Are you entering this plea freely, willingly, and knowingly?
Yes, I am.
In that case, it has been explained to you that if you decide to plead guilty to this charge, you would have to give up your right to a trial in front of a judge or a jury. There will not be an opportunity to confront your accuser, challenge the evidence brought against you, be able to present your own defenses and arguments, and the state will not have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
That's now, I think I am.
You think?
Yes, I'm sure.
You're sure? That's good. How do you plead to criminal trespass causing damage to property at the Legends Cafe?
The proper answer is guilty. I'm supposed to say guilty, right? Yes, you say guilty. Guilty.
That's what I like to hear, something with conviction, because if you're wavering, I'm not going to accept it. I'll accept your guilty plea. Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other cases holding you at the jail, you should be released within 24 hours. You will report to probation on Monday, March 10th before 3 p.m. And while you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will start your probation at a minimum rate of 5 hours per month. You can do more if you choose to do so, but it must be a minimum of 5 hours. And if you complete your community service, you're up to date with your probation fees and surcharges, then your probation will be non-reporting. At all times, you are to stay away from the Legends Cafe at 5110 Old National Highway, Suite B in College Park. Thank you.
Thank you,
Eric Jones?
Yep, position number 10, Mr. Jones.
Thank you. This is State versus Eric Jones, case 25 CRs 874E, accused of theft by taking. Mr. Jones, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Shatay. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I'm sorry, I can't hear you.
Yes.
Okay, thank you. You may place your hand down. Mr. Shatay, this is a negotiated or non-negotiated plea?
This is a non-negotiated plea, Your Honor.
All right. Mr. Jones, the prosecutor is going to give her recommendation as to what the sentence should be, and then your attorney will give me his recommendation. Based on the information we have, including your criminal record history and the nature of the charges, I will let you know which option I will select, keeping in mind that I have a right to refuse either option and set the case down for trial. Ms. Tucker?
Yes, Judge. The state is recommending 12 months to serve 30 days, credit for time served 15 days, balance probated, to complete the anti-theft course, complete 40 hours of community service, to have no further contact with Akil Scott, and to stay away from Moody's Wrecker Service at 3845 Conley Street in College Park. This recommendation is based on his history. He does have 2 convictions for theft by receiving stolen property, one from 2010 and one from, the other one was a first offender plea from 2010. But based on the thefts in his history, paired with the facts of this case, he was working at Moody's Wrecker Service. When someone came to claim their car, his PS5 was missing out of the trunk. So they sent out a mass text to all the employees, please return this PS5. And he was seen on video returning the PS5. However, there were cords missing, headphones missing. So the entire, the PS5 was returned, but not the entirety of the stolen goods. So for those reasons, we're not asking for any additional jail time. I understand he served 15 days, but I am requesting that that anti-theft course, 40 hours community service, no further contact with this victim, and to stay away from the Moody's Record Service.
Mr. Shate, your client has an open felony matter. Is that holding him at the jail?
Yes, Your Honor. And that he's being held on that with no bond.
Understood. All right. And what is the defense recommendation?
Your Honor, my client would object to the anti-theft course and 40 hours of community service, and he would also like to ask for the lowest probation period possible.
And on what grounds?
He's here on the aggravated assault.
Yeah,
on the,
that I do know, but I'm what
on-
independent of his felony charge, why should I consider this is a theft charge? And I'm looking at his history. He was booked into Fulton County Jail in 2023 on a probation violation. And this is just Fulton County. Possession of firearm by a convicted felon, possession of marijuana less than 1 ounce. This was all back on June. Yeah, these were from 2017 charges. In 2020, he was booked in again on drug charges, felony charges. 2020, that was July 2020. Then January 2020, more drug charges and firearm charges. I'm sorry, Mr. Shate, I need a good reason on why these conditions are not applicable to Mr. Eric Jones.
My client has a question. Could I confer with him? He's trying to.
Sure. Please mute your screen.
All right, so in addition to the other charges that's holding him here, Your Honor, my client also informs me that he is, before coming here, he was in a drug program in Cobb County, and he was working on getting improvement there as well. So he believes that the anti-theft course and 40 hours of community service might interfere with his obligations to that court.
Is he required to do an anti-theft class in that program? Right. And how many hours of community service is he required to do in that program?
Basically, like that's why I do all my class stuff like that. Like I don't really need program.
Your Honor, my understanding about the program now is that he takes classes there. It's an in-placement program, and he has to attend those. So that's as much as I know about that.
All right. Mr. Jones, I do understand that you're in a program in Cobb County, but just because you're in one kind of program doesn't mean that it fits the requirements for the charge that you're willing to plead guilty. I don't know what charges you pled in Cobb County, but in Fulton County today, this is a theft charge of someone's personal property, and the allegations are that the item was returned in a damaged condition. So, or incomplete condition. So that is in and of itself an alleged theft charge. And the minimum requirement is to at least get you exposed to an anti-theft class and 40 hours of community service. If you don't want to do the community service, it will be a $400 fine. And if you don't want to do the anti-theft class, then it will be a $1,000 fine. So you tell me whether you want to pay a $1,000 fine or whether you would like to do 40 hours community service and the anti-theft class.
Classes. Yeah, I take the class in the community service.
All right. In that case, Mr. Shetty, do we then stipulate to venue and ID?
Yes, I would stipulate, Your Honor, I also ask the court to consider placing him on a non-reporting status once he completes these requirements.
Denied. I need to make sure that he reports and that he stays out of trouble. It's only once a month. All right, are we ready to proceed, Mr. Shetty?
Yes, Your Honor.
Thank you. Mr. Jones, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case? I'm sorry?
Yes.
And are you satisfied with your legal services?
Yes.
If you decide to enter this plea, it must be done so freely, willingly, and knowingly. Have Mr. Shetty and you discussed the waiver of rights?
Yes.
So you understand that if you plead guilty to this charge, you would have to give up your constitutional right to a trial. You will not be able to go back to court to face your accuser, challenge evidence brought against you, present your own arguments and defenses through your counsel, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of theft by taking from October 11th, 2024?
Guilty.
Repeat.
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. Once you are released from probation, from your current case in Superior Court, you will report to probation, Fulton County Probation, immediately upon your release on a Monday, Tuesday, or Thursday and before 3 p.m. Fulton County Probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete an anti-theft class and you will enroll in that program within 60 days of being released and begin your class. You will also complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. And you must do the 40 hours at a minimum rate of 5 hours per month. At all times, you are to have no contact with Akil Scott, and you must stay away from the Moody's Wrecker Service at 3845 Conley Street in College Park, Georgia. You will report to probation every month until the remainder of your 12 months is completed. Thank you. That's cold. Okay. Yeah.
I don't get no paper or nothing. Sorry, I don't get no papers or nothing.
All right. Mr. Shetty, I don't know of any other cases for you on this calendar. I think Mr. White's have also been addressed. Mr. White, did I need to address any of your cases? No?
No, Your Honor.
Okay. And then, Mr. Haddad, do we have any cases to address?
No, Judge, not in terms of pleas. We're done. I don't know if we're gonna go over the calendar. I know I was stepped away, but if there are any announcements.
On the add-on calendar, Lionel Carter was transferred to Superior Court. I think that was your case.
That's correct.
And then, Calvin.
Sorry, didn't mean to interrupt. I just sent the order to Ms. Champion with the DA's office signature.
Okay. Walter Price, position 4 is reset to March 11th for Mr. Dennis Murphy to hopefully get in touch with him and speak before we proceed. And
Excuse me, Judge. He did reach out to me about 3 minutes ago, and I told him we reset the case.
March 11th, right?
Yes, yes,
Thank you.
Mhm.
Gregory Rice was a plea. Adriana Segre was reset to March 13. Thompson reset to March 13. And Ernest York were all pleas. And then the bench warrant was null pros. So I believe that completes the SAP calendar. Mr. Bartel, is he available?
Judge, am I needed? Are we excused?
Oh, you're definitely excused unless you'd like to stay for 11 o'clock, then you're more than welcome.
No, I'll skip.
Thank you.
Thank you, Mr. White. You're free to go.
Thank
All right.
Yes,
Miss-
Your Honor. Good morning.
Good morning. And is Miss Kasha or Miss,
Ms. Kasha is here.
okay,
I don't see Ms. Burgess, but I think we can go ahead with the competency calendar, Judge, if you want.
all right, Miss Grace?
Oh, excuse me, Your Honor. PD Bartels, the case that you wanted to enter a plea on the competency calendar, do we need to address that today? Because we
Well,
did.
yes, I had emailed
keep people out.
last night. It's Mr. Riley. He's number 8 on the calendar, and that would be a time served plea if the court will accept that. I don't know if he's available now. He's on, I think, 3 South.
Okay, I don't have 3 South as appeared on the main session. So Miss Grace, the individuals whose videos are on, could you put all 4 of us in a breakout room? And if 3 South appears, could you please ask them to hold?
Okay, Judge.
Thank you. All right, courtroom 2, are you available? Oh, I see an iPhone over here. Oh, it's Miss Burgess. Miss Burgess,
Yes.
I'm so sorry. We finished with our competency
All
calendar.
right.
Yeah,
Okay.
and Mr. Bartel would be glad to give you an update. Most of them were reset to March 20th.
Okay.
Yeah,
Okay.
I don't think there's anybody.
Okay. All right. I'll get with him.
Okay,
Yeah,
thank
they're either people who need an evaluation, Kia, or one is pending, and
Okay.
not really anybody, that
Okay.
has a placement in progress.
All right, and courtroom.
Okay. All right. Just wanted to check in.
Okay, thank you.
Thank you.
All right. Bye-bye.
Bye-bye. Mr. Bartel, I'm not very optimistic about being able to reach Mr. Riley at this juncture. We have concluded with the calendars. And were you quite certain about the plea?
Well, I believe that I believe he is able to enter a plea, especially to a charge like this. I think there are some problems with some speed of information processing. He needs things explained to him a little slowly, but I believe he understands.
Is it a time served plea?
It would be a time served plea, yes, Your Honor. And I did send an email, well, that was late last night, about asking that it be brought down for a plea.
All right. Well, here are a couple of options. I don't want to keep everybody else waiting because I have no ETA on Mr. Riley. Judge Morrow is doing the C calendar. If you want to reach out to the jail and see if they can bring him in at the 2 o'clock calendar for Judge Morrow to take the plea. Tomorrow is going to be Judge Williams for the C calendar. And you can see if you want to do the plea at 2 o'clock tomorrow. Then I will be doing the C calendar on Saturday. Mr. Bartel's like, I have to do this on Saturday.
I'm trying to work out something today so that he doesn't have to spend any more time in jail. I'm also wondering, how I can avoid this in the future, so that we can get it lined up before.
I wish I could give you a quick answer about how to make sure we can get him in the queue to be available in the courtroom.
Have you reached out to Norris PD Bartels?
I sent an email to him and the other deputies last night. It was actually like early this morning.
I have a contact over at the jail. Let me reach out to them and see if they can bring him for SCA today.
Okay, just give him the booking number also, 2502-905.
Will do.
All right. Anyone else who is Miss Kasha can stay. She's more than welcome. Pre-trial, Miss Washington, you're free to go. Is there probation required for? Bye-bye, Miss Washington. Is there probation required for Mr.
No,
Riley?
it is a balance suspended plea, Your Honor.
All right, so probation, you are also excused. And I have James with FC State Court, who might be observing. You're more than welcome to stay for the possible plea for Mr. Riley. And we will take a 5-minute recess for Mr.
If I may, Your Honor.
Yeah.
PD Bartels, Mr. Riley has 2 holds. So regardless of what happens today, he's not getting out. He's got 2 different holds, one from Forsyth and one from Snellville.
Right. I talked to the Snellville Police Department. The one from Forsyth just recently popped up, but Snellville told me that is not an active hold. At one point, there was something out for him, but I think when the Fulton County calls Snellville, they'll advise him that's not a hold. I haven't been able to determine what Forsyth is about.
So it'll still be a time served plea and a release to the hold, whichever one is there. So we can take a 5-minute recess for Ms. Folk to consult with Deputy Norris and give us an ETA or a reset.
Okay, that sounds good. So it would be a reset for SCA tomorrow for a plea?
Well, today,
Today.
today
Okay.
with Judge Morrow or tomorrow with Judge Williams? Or, I really don't understand. Saturday is a wonderful event. I mean, what else could you be possibly doing on a Saturday?
Who wouldn't want to do that on a Saturday if it wasn't necessary?
All right, folks, 5-minute recess. Thank you.
Okay. All right, thanks for your help, everybody.
Ms. Falk, any updates?
Unfortunately, I haven't gotten a response. I have asked them to bring the defendant to SEA just out of an abundance of caution so we can see if we can get them to the 2 o'clock calendar. But I will come to the 2 o'clock calendar and I will let PD, I see PD on it as well. So as
Yeah,
soon
I
as
got
we
it.
get a response, he'll receive it as well.
Okay, I'll let Judge Morrow know that he may have to take a plea and then we'll do it. I have a Rotunza Phillips on Zoom. Mr. Bartel, is that someone related to your client?
She is the
that is
victim
not
in
mine.
right. She is the victim in one of our cases, Your Honor. That is the Calvin Drake case, position 2 on the add-on calendar.
Rotunza Phillips, did you have a question of the court before we close the Zoom session?
No, ma'am, no, ma'am.
Okay, then we conclude the session then. Thank you, everyone. Take care.
Okay, thank you. I'll just check in for the 2 p.m. calendar, Ms. Falk, and thanks for your help with that.
Thank you. Bye-bye.
Bye-bye.
Bye.